Day in, day out, people get arrested because they do not know the law, or they haven't even read anything concerning the laws of Ghana. There are a lot to digest in the laws of Ghana, and today is another episode under the Law Gist. If you are new on this channel, please hit the subscribe button and turn on the post notification. A special thank you to all old and returning viewers. Thank you very much. Today, I'll be discussing with you cases where one crime is abetted and another crime is committed, or cases where one crime is abetted and a different crime is committed. Stay tuned and enjoy this gist. Today, the topic is cases where one crime is abetted and a different crime is committed. Here, we are taking our reference material from the 29th Act of the Parliament of Republic of Ghana, which is entitled Criminal Act 1960. We will be taking the main reference from section 21, which is the same as the topic I am tackling today, which is cases where one crime is abetted and a different crime is committed. Abetment basically means trying to agree before you do something, or someone aiding in something, or someone having a hand in a crime or unlawful act. Subsection 1 says, where a person abets a particular crime or abets a crime against or in respect to a particular person or thing, and the person abetted actually commits a different crime. So this is trying to say that if, let's say, I'm the abettor and then I tell you to go and rob a house, but I didn't tell you to kill anyone in the house, but you go to the house and then you kill the person you are going to rob, what I said wasn't in relation to what you have done. So A, if it appears that the crime actually committed was not a probable consequence of the endeavor to commit, nor was substantially the same as the crime which the abettor intended to abet, nor was within the scope of the abatement. So this is, like I said, if the crime committed isn't a probable consequence of what the abatement was. If you go and kill someone to steal something, but the agreement or the abatement was that go and just steal the thing, but don't kill anyone, then the person or the abettor will be held liable accordingly, but won't be charged for a murder in this case, but would be charged for aiding and abetting in that crime of stealing. So there is a case here which is Tay alias Bardo versus the Republic. In this case, 3 people went to steal something. In the act, they ended up killing the person who was in the house. So in this case, they all agreed to go and steal, but they all didn't agree to go and then kill anyone in the house. You get it? So in this case, whoever that killed the person in the house will be charged for murder. But then the rest who agreed to just go and steal will be charged for stealing or any other charges that are related to their crime, but not purposely for the murder or for killing the person who was in the house, because that wasn't what the abatement was, or that wasn't what the agreement was. So paragraph B says, in any case, the abettor shall be deemed to have abetted the crime which was actually committed and shall be liable to punishment accordingly. So in as much as sometimes in this case you will be liable for only the abatement, sometimes you can be liable for the cause, the intended cause, if the abatement is equivalent or equal to the results or the consequences. So there is a case here, Rex versus Croft, CCA 1944. A person who was present at a suicide of another who assisted or encouraged the suicide. So it was someone who was present at someone killing themselves, and this person actually aided or abetted by helping the one who was committing the suicide. So this person who helped someone to commit the suicide was liable to was guilty of murder and was charged which was a second degree, the survivor of the suicide pact was probably convicted of murder. The court decided liability for suicide as an accessory. So in this case, you help the person knowing that if the person is to hang himself, he's going to die. So the action is equivalent to the probable cause or the consequence. And in this case, you will be charged of the consequence that will happen. Now, step 2. If a person abets a riot or unlawful assembly with the knowledge that unlawful violence is intended or likely to be used, he is guilty of abetting violence of any kind or degree which is committed by any other person executing the purpose of the riot or assembly. So if you are to gather people, mobilize people to go and do something, and then you know that the purpose to be achieved will definitely be achieved through violence, it means you are abetting to violence, and then you will be charged according to that. So there is an illustration here which says, if an A, we have an A party, B, and then the C party. So if A incites B to commit robbery by threat without violence to C, and then B attempting to commit the robbery, C is resistance, and B murders C. Here, A is guilty of only abetting to robbery, like I explained in the first part. He had no hand in the murder, but B is guilty of murder. But in, let's say, scenario A, B, where we have A, B, and then C party, and then A incites B to steal a horse, B, in pursuance of incitement, gets the horse by false pretense. Here, A is guilty of abetting with the crime B has committed, in that the abatement or the agreement is equivalent to the end result. You understand? Let's go to subsection 2. It says that persons assemble together for purpose of breaking open a prison and releasing a prisoner by force. Some of them are armed. If murder is committed by one of these in breaking open the prison, all persons, whether armed or unarmed, who took part in or otherwise abetted the breaking open of the prisons are guilty of abetting murder, if they knew that arms were carried and were intended unlikely to be used. So this is if, for example, you want to go and set someone free from the prison, and then you send people. This is talking about not only the people who actually went, but if you are home and then you took part in the abatement or the agreement that we should go and release this person from prison, and then they go and you know that one is having a weapon or some of them are having weapons, and then they kill someone, all of you are liable for murder, because the person having that arm or the person having that weapon, you know that gun can be used to kill someone, or any weapon can be used to injure someone or kill someone. So if the person uses that weapon to hurt someone or kill someone, all of you are liable for murder. Understood? So there is a case here, Regina versus Genfi, 1960. The fact is that the appellant was leading a number of supporters of the United Party to get towards a crowd of supporters of the Convention's People Party. In this case, someone threw a stone and then it struck Kwabena upon on his right side. So the stone was not presented to court, but then they described it to be a huge stone, like a big stone. And after the postmortem, the person, which is Kwabena upon, died. So after the postmortem, they realized that there was the cause of the death was as a result of bleeding or rupture from the liver, and then also as a result of the impact of the stone at the right side of the one who died. The issue is that Whether or not the appellant throwing the stone into the crowd was done in consciousness that it was likely to cause the death of the deceased. So, did the person know that throwing the stone was going to cause the death of the person or the deceased person here? And then the holding is, the court held that the appellant had no intent to kill from his act. It can be inferred that he intended to cause harm, because throwing the stone, maybe it might not come to it might not cross your mind that the stone is likely to kill someone, but then you know that the stone is likely to injure someone or hurt someone. So the holding of the court is that the intention, I did mention here, which talks about having the intent, what you think. So you can go and refer to that video. The intention of this person was to harm someone in the crowd. So in this case, he was held liable for that. So therefore, his murder charge was substituted for manslaughter, because there was no sufficient information that held that he throwing the stone was probable to kill someone. But then, if he had any other person who abetted or aided in his action, both of them will be charged for whatever this person was charged for, because you know that throwing the stone is highly probable to cause harm to someone within the crowd. This brings us to the end of today's video. I hope you are educated and enlightened about this. Be careful what you agree to do as a group or even with your close friend, because at the end of the day, if whatever the person did is in accordance or is in equivalence to whatever you guys agreed, and it is to cause harm or unrest, or it is unlawful, that can send you to prison. So that is what, if you abet something, and then if the person actually commits a crime which wasn't part of the agreement or the abetment, the person suffers his own consequences or her own consequences, because that was in the agreement. Nevertheless, you having a role to play in the act will be charged accordingly. So be careful and then stay safe. Thank you very much for consuming this content. Like I said, if you are old on this channel, thank you very much. If you are new, please don't forget to hit the subscribe button and turn on the post notification. Both old and new, kindly invite more people so they join this family. Thank you very much.